Hello and welcome to ProfDale's Property Video number 35. I'm your host, Dale Whitman. In this video, we're going to talk about the ways that easements can be created. Now, there are only 4 ways of creating easements, and we're going to list all 4 of them on this slide, and then we'll go through each one in detail and see how it works. The 4 ways of creating easements are express easements. They can either be by a grant or a reservation. And we'll just note here that the statute of frauds applies only to express easements and not the other 3 kinds. The second way of creating an easement is an implied easement. Again, it can be by either a grant or a reservation, as we will see. The third kind is the easement of necessity. And the fourth kind is the easement by prescription. You can easily remember all 4 of these ways of creating easements if you just remember the word pine, P-I-N-E. P stands for prescriptive, I for implied, N for necessity, and E for express. So the word pine will remind you of all 4 ways of creating easements. Now you might wonder, why does the statute of frauds apply to express easements but not to the other 3 types? Well, the answer is that the other 3 kinds of easements, that is, implied, necessity, and prescription, those easements are all created not by words but by conduct. And therefore the statute of frauds has no application to them at all. But for an easement that is express, in most states if it's longer than 1 year in duration, we do need to use a writing. We'll begin then by talking about express easements, easements that are created by words. To illustrate how an express easement works, let's take this little example. Owner 1 and owner 2 live side by side, and owner 1 has a garage beside his house and would like to have a driveway that runs over the corner of lot number 2 in order to get owner 1's car into and out of the driveway. So we need an easement created for owner 1. Now that would be an express easement, that is, it's going to be created by words, and as we'll see, it can be created either by a grant or by a reservation. Let's begin with a grant. In the grant situation, what happens is that owner 2 grants an easement using a deed to owner 1. So we might say that the servient owner grants the easement to the dominant owner. Is it necessary to provide in the grant a legal description of the servient land? Well, yes, the statute of frauds is going to require a description of the land that the easement runs across. What about putting in a legal description of the exact location of the easement on the servient land? Well, no, that isn't strictly required. It's almost always a good idea to do that, but it isn't essentially necessary in order to create a valid easement. What about a legal description of the dominant land? If the easement is appurtenant to a piece of dominant land, as it is in this example, the dominant land would be lot 1. Do we need to describe the dominant land? Once again, the answer is no. Again, it's an excellent idea to do that, but it isn't legally essential. If we don't say what the dominant land is, the courts will try to figure it out from the facts and circumstances. Where do the descriptions come from? If we want a description of the dominant land or the servient land, where can we get one? Well, the answer is almost always there will be existing recorded deeds. Often the owners will also have title insurance policies, and both the deeds and their title insurance policies will contain legal descriptions of their property. So it's easy to get that. On the other hand, a legal description of the exact location of the easement on the servient land is not so easy to come by because that's a new phenomenon. We don't have any existing document that will give us a legal description of the exact location of the easement. So, which is better, to put in an exact location or not? The easy way, the way that's less expensive, is to simply say that we're granting an easement for a driveway over lot B, as shown in a plat book of a certain page in a certain county in a certain state. But that doesn't tell us exactly where the easement is on lot B. The better way is to say it's an easement for a driveway over lot B, and then to say exactly where the easement is located. A legal description of the easement might begin by saying, with the northerly boundary of the easement beginning 27 feet north from the southwest corner of Lot B and then we'd continue with an arc down to the bottom boundary, across the bottom boundary, and another arc back up to the side boundary and back to the point of beginning. It's a little more complicated and it will be more expensive because we'll probably have to pay a surveyor or an engineer to do it. But it's certainly a preferable way if we can get the parties to spend the money to create an exact location of the driveway on the servient land. Now, if no legal description of the easement boundaries is given in the document, we call it a floating easement. And a floating easement can be put anywhere on the servient land that's reasonable. It's up to the dominant landowner to decide where to put it and place it on the servient land. However, once it is fixed in place on the ground, it's no longer floating, and the courts will treat that location as its permanent location. Are floating easements sometimes useful? Well, they are. For example, imagine that you're in charge of acquiring land for a new power line across open countryside. You go to a farmer and say, would you be willing to give me an easement for my company to put power lines across your land? And the farmer says yes. You say, well, I'm not able to tell you exactly where I'm going to put the easement at this point because, of course, I have to also negotiate with the farmers on either side of you and get easements from them, and they may have preferences about the location of the easement, and I have to make them match up so that I'll have a continuous easement across all of these parcels. So may I make it a floating easement at this point? The farmer may say, all right, within some limits at least, I will give you an easement that's floating, and you can fix it later by actually installing the power lines and poles. So what do we want to state in the grant of an easement? Well, here's a little checklist of things that we need to say. First of all, we ought to say that it is an easement rather than a possessory estate. Second, we ought to say what the location of the easement. Now, as we've already indicated, the best practice is to describe both the servient land parcel itself and the location of the easement on the servient land. But at a minimum, we have to describe the servient land, even if we allow the easement itself to be floating. Third, we need to say what the scope of the easement is. In other words, what is the person who gets the easement allowed to do with it? It might be for a driveway, a power line, a water line, a sewer line. You can think of lots of uses, but we need to say in the easement what the scope of use is. We need to say whether it is an appurtenant easement or an easement in gross. Remember, an appurtenant easement is one that has dominant land. An easement in gross does not have any dominant land. Usually, it will be obvious from the context which of these types of easements we mean, but it's always best to state in the grant of the easement whether it's appurtenant or in gross. If it's appurtenant, we need to say to what dominant land it's appurtenant. And again, the best practice is to actually include a legal description of the dominant land. Is it going to be an exclusive or a non-exclusive easement? Easements can be either one. The presumption is that the easement will be non-exclusive so that other people, including the landowner and other grantees of easements from the landowner, can also use the easement's pathway. If we want it to be exclusive, we need to say so. How long is the easement going to last if it's not in fee simple absolute? The presumption is that easements will be in fee simple absolute, but they might be for a lesser period. Finally, we ought to say who has the maintenance responsibility for the easement. That's particularly important if it's non-exclusive and the owner of the land is also going to be using the easement's pathway. If it's an exclusive easement, the courts will presume that the holder of the easement has the maintenance responsibility. But if it's not exclusive, then that's not so clear, so we need to spell it out. Now, so far we've been talking about easements by express grant, but an easement can also be created by an express reservation. To illustrate that, let's assume that owner 1 actually owns both lot 1 and lot 2. So owner 1 deeds lot 2 to owner 2, and in the same deed that deeds out lot 2, owner 2 reserves an easement over lot 2 to benefit lot 1. So the basic principle of an express reservation is the owner of both lots conveys out the servient land and at the same time in that same deed reserves an easement to benefit the retained land that the grantor is keeping. Now there's a common mistake that people often make when trying to reserve an easement. It's illustrated by the picture we have in front of us. It's called a reservation benefiting a third party, and it's simply not allowed. What happens in this situation is that a common owner, let's say the developer of this subdivision, sells lot 1 to owner 1. Later, the developer is about to sell lot 2 to owner 2, and owner 1 comes to the developer and says, listen, when you sell lot 2, would you mind reserving an easement across lot 2 for a driveway going to my garage on lot 1? The developer says, no problem, I'll be happy to do that, and executes a deed to owner 2 that reserves an easement in favor of, for the benefit of, lot 1. What's wrong with that? Well, the answer is the developer doesn't own lot 1 anymore, has previously sold it, and you're not allowed to reserve an easement to benefit land that you don't own. Now, this is in some ways a silly rule. It's a very ancient rule, and it really doesn't serve any modern purpose. It ought to be done away with, but it's still the majority rule. It's an easy rule to avoid. If you think about it, you can see how to do that. What the developer could do is deed lot 2 to owner 1, have owner 1 then immediately in the same transaction deed lot 2 to owner 2, but reserve the easement across it. That way we don't violate the rule because the party reserving the easement is reserving it to benefit his or her own land. So it's an easy rule to avoid, but be very careful not to make the mistake of trying to do it directly. There's one other way that an easement can be created by express words, and it's in a subdivision plat. Now, a plat is simply a map of subdivided land. Usually it's a map that's officially recognized by the local government and is recorded in the public records. And the map itself may indicate the existence of certain easements. For example, the red arrow in this one points to a legend that says 60-foot private road and utility easement. So the easement would be created just by showing this on the map and publishing and recording the map so that people are buying their lots with reference to it. When we have public street easements that are created on a subdivision plat, and commonly the plat will actually state that it's a public street, then not only are there public easements in favor of the local government for the streets, but at the same time, private easements are also implied. If that subdivision plat is approved by the local government and recorded, and the plat shows the streets as dedicated to the city, private easements in the streets also arise in favor of the lot owners. Now you might think that's not very important because it's a public street anyway. But what happens if in the future the local government vacates the public easements? They say, we're not going to treat these as public streets anymore. Normally they will only do that at the request of many or most of the lot owners in the subdivision. But if the public street is vacated, the private easements still exist. The reason for that is that if they didn't exist, then a person that owned an interior lot in one of these subdivisions wouldn't be able to get to or from his or her lot because there would not be any easement at all. So the private easements continue to exist even if the public easements are vacated. Well, that wraps up our basic discussion of the creation of express easements by grant or by reservation. We're going to take a little side trip now, and before we cover the other ways of creating easements, we're going to ask ourselves this question. What happens to an easement if one of the affected parcels of land, either the dominant or the servient land, is later transferred? Now, what we're going to cover here really applies to all four of the ways of creating easements. So let's imagine that we have our situation with Lot 1 and Lot 2 and the driveway. Lot 1 is the dominant land, Lot 2 is the servient land. Suppose A buys lot 1. The question before us is, does A also get the easement? And the answer is absolutely yes. If you buy the dominant land, you automatically get any easements that are appurtenant to that dominant land. They don't have to be mentioned in the deed. A will get them whether they're mentioned or not. Notice that an appurtenant easement can't be transferred separately from its dominant land. So if owner 1 tried to transfer the lot to one party and the easement to another party, it simply wouldn't work. The easement has to stay with as if it's hooked onto the dominant land, and anybody who gets the dominant land will get the easement. Now let's take a look at the other side of the easement, the servient land. Suppose the owner of lot 2 sells it to B. The question is, does B take subject to the easement? In other words, does B have to recognize the easement and treat it as valid and allow it to continue to be used? Well, the answer is yes. If B has notice of the easement, that means we have to ask ourselves the question, how could B get notice of the easement? And it turns out there are 3 ways. A purchaser of land can get notice that it's encumbered by an easement in any of these ways. First, they might get actual knowledge. Somebody might tell them that the land that they're buying has an easement running across it. In fact, if the owner of lot 2 is honest, the owner of lot 2 will tell the buyer of the lot there's already an easement in place across the land that you're buying, and you'll have to recognize it and take subject to it. But people who sell land with easements across it are not always honest and don't always give actual knowledge to their buyers. A second way is that the easement might be visible from inspecting the property. Everybody who buys land is expected to look at it first. And so if you're about to buy a piece of land and there's a road or a driveway or something else running across it that you can see that looks like an easement, you're expected to inquire about it. You can go to the land that it runs to and ask the owner of that land if they claim an easement over the land that you're buying. If you don't do that, you're simply held to have the knowledge that you would have gotten if you had carried out that inspection and inquiry. Now you'll notice that visible from inspection theory doesn't always work with easements because some easements are underground. Often power line, water line, sewer easements are buried in the ground, and there may or may not be anything on the surface that tips off an owner that there's an easement down there under the soil. The third way that a person who's buying a piece of land with an easement across it might find out about it is that the easement might be recorded in the public records. Of course, everybody who buys a piece of land is expected to do a title examination in the public records first. So if the easement has been recorded, then that will tip off a person who is buying the land that the easement exists. And if they don't bother to do the examination of the public records, they are simply held to the notice they would have gotten if they had done that examination. Now, in addition to express easements, we've said that there are 3 other ways that easements can be created. And you can use the 4 ways of creating easements as a sort of checklist. There are implied easements, there are easements by necessity, and there are easements by prescription. Anytime you get an easement question, either on an exam in law school or in real life, when a client presents one to you, you need to think about each of these 3 ways of creating easements in addition to the express easement that we've already covered. We're going to examine all 3 of the other ways now, and we'll begin with the implied easement. We ought to call an easement that's implied from prior use, because that's really how an implied easement arises. It arises from prior use, as we will see. Let's take a look again at our picture of Lot 1 and Lot 2 and the driveway. Let's assume that there is no written express easement, but let's assume that the same person owns both lots. We'll just call them the owner. And while they own the lots, they put in the garage, the driveway and they begin using the driveway. Now at this point, of course, it's not an easement because the same person owns both the dominant and the servient land, and you can't have an easement on your own land. However, the owner does install the driveway, begins to use it, as I said, and uses it to benefit Lot 1 for a long period of time. Then the owner sells one of the lots, it could be either Lot 1 or Lot 2, to a new owner. Well, at this point, it's very possible that an implied easement will arise. Now you'll notice there is no writing here. In fact, I sometimes like to say that express easements are for smart people and implied easements are for stupid people, because sometimes a court will give someone an easement even though they were too foolish to get it in writing. That's what an implied easement is. So what are the elements that have to be proven in order to create an easement that's going to be implied from prior use? Well, the first thing we have to show is common ownership. That is, that the same person owned both the dominant and the servient land. When must there have been common ownership? Well, the answer is immediately before the easement arises. Second, there must have been a quasi-easement while the lots were in common ownership. And by a quasi-easement, we mean continuous or permanent use of one part of the land to benefit another part of the land while both parts were in the same ownership. Third, the easement or quasi-easement must have been apparent or obvious or visible to anybody who bought either of the parcels of land. Again, that means that sometimes buried in the ground easements won't work because they're not visible. Finally, the easement must be reasonably necessary to the use of the dominant land. Now, this isn't a strict standard. Usually when the courts say reasonably necessary, all they mean is it's very convenient for the dominant landowner to have access to this easement. So those are the four elements of an implied easement from prior use: common ownership, a quasi-easement, apparent, obvious, or visible, and reasonably necessary. An implied easement might be created either by a grant or by a reservation. It depends on which lot is sold first by the common owner. If the common owner sells Lot 1, then the easement that arises would be an implied grant. If the common owner sells Lot 2 first, then it would be an easement by implied reservation. It's interesting that some courts require a little higher degree of necessity for an easement by implied reservation than one for an implied grant. Can you think of why that might be? Well, consider that in the implied reservation situation, it is the common owner himself or herself who's going to get the easement. Well, obviously, having already owned the property for some time, they know all about the need for the easement. They know all about where it's located. It should be obvious to them that they need to get an express easement. So it's really asking quite a bit to get a court to give them an implied easement. What's more, in the implied reservation case, where Lot 2 is sold first, it's the common owner who normally drafts the deed, or the common owner's lawyer or scrivener will draft the deed. So they have every opportunity to put in the deed an express reservation of an easement. So because it is so easy for the common owner to get an easement by implied reservation, and so obvious to them that they need one, the courts are a little suspicious when somebody asks for an easement by implied reservation, and they may very well require a higher degree of necessity than they do for an implied grant. Whether the original easement was an implied grant or an implied reservation, there is a further notice issue that arises anytime the servient land is resold in the future. In fact, this notice issue applies to all unwritten easements. And the reason it exists is that if the easement isn't still apparent, then the subsequent buyer may have no notice of its existence. And if a buyer buys a piece of land with an easement across it, but has no notice of the existence of that easement, then that buyer is considered a bona fide purchaser, a BFP. If they buy with no notice of the easement, they will take free of the easement, and the easement will, in effect, be terminated by virtue of the BFP buying the land without notice of it. So the apparentness or obviousness of the easement can become critically important every single time the servient land is resold in the future. You'll notice that in this situation, the buyer can't find out about the easement from searching the public records because it's not written, and therefore there can't be anything in the public records about it. The third way of creating easements is called the easement of necessity, and the donut is there for a reason. An easement of necessity often looks very much like a hole in a donut. Here's an example. A developer owns a large parcel of land with a road on the north and a road on the south. The developer subdivides that land into 7 lots. 1, 2, 3, 4, 5, 6 all have access to a public road, but lot 7 is in the middle and has no direct access to a public road. So if someone buys lot 7, they're obviously going to need access, and the way they will get it is by asking the court to recognize on their behalf an easement of necessity. So what are the legal elements that have to be proved in order for someone to get a common law easement of necessity? Well, the traditional view was that you had to have a landlocked parcel, that is, one that had no access directly to any public street or road or any other private easement for that matter. So the traditional view was that there must be absolutely no other access to the property. Even if there was other access that was very difficult to use, very inconvenient, it went through creek beds, it went over mountaintops, nevertheless that would knock out the idea of an easement of necessity. The modern view is a little more relaxed, and the issue is usually something like this. Without the easement, can the land be effectively used? Is there any other practical way to get to the property? And if there isn't, then the owner may be able to get an easement of necessity by decree of the court. The second thing that has to be proven is common ownership. That is, common ownership of the landlocked parcel and some other land between it and a public road. How long ago must the common ownership have existed? Well, the courts vary on that, but many of them would say you can go all the way back to the beginning of the record of ownership of these parcels. And if they were all owned by a single owner even a long time ago, that will be sufficient. And if you think about it, that's almost always true, because you can almost always go back to a time when there was original government or sovereign ownership, and that will be sufficient. What is the scope of an easement of necessity? What can you use it for? Well, you can use it for access, obviously. That's the main point of it. Pedestrian and vehicular access, any reasonable sized vehicle will be okay. You can also use it, according to the modern cases, for utility lines, to bring utilities into the landlocked parcel. But you can't go beyond that, so you won't be able to use it for parking or for building or any other use. Let's suppose that there is an easement of necessity. Suppose owner 7 has gotten the easement of necessity. Let's suppose it runs across the edge of lot 5 to the south road. Now a new public road is put in between the two existing public roads, and that new public road touches lot 7. What happens to the easement of necessity across lot 5? Does it still exist? The answer is no. An easement of necessity will last only as long as there is necessity. And if the necessity no longer exists, the easement of necessity will terminate. The final way of creating easements that we need to cover is the easement by prescription or prescriptive easement. And easements by prescription are very similar to adverse possession, except that they arise from mere adverse use rather than full possession by someone who's trespassing on the property. So what are the legal elements that have to be established to get a prescriptive easement? Well, they're very similar to the elements for adverse possession. You may remember that when we covered adverse possession, we used the word OCEAN, O-C-E-A-N, to remind us of the 5 legal elements that have to be proved. With a prescriptive easement, there are only 4 elements, O, C, A, and N. E isn't on the list. O stands for open and notorious. So to get a prescriptive easement, one must use somebody else's land in a way that you can be seen, that you're obvious to people who might pass by. Second, your use has to be continuous. Again, that doesn't mean 24 hours a day, but it does mean on a regular and uninterrupted basis. It's got to be actual use. You've got to really engage in some activity on the land that doesn't belong to you. And finally, your use has to be non-permissive. If you have the owner's permission to go across their property, you won't get a prescriptive easement. Why isn't exclusive an element of prescriptive easements? Well, the reason is that easements in general are not exclusive. Most easements are non-exclusive, in fact, so that normally if you have an easement across somebody else's land, they're entitled to use that same strip of land for their own purposes or to give other people the right to use it, as long as that doesn't unreasonably interfere with your use. So exclusive simply doesn't fit in the lexicon of easements. Usually the time period for a prescriptive easement is the same as the period for adverse possession. There are a few states in which by statute it is a different period, and you need to be alert for that, but usually it's the same. One of the challenges with prescriptive easements is that sometimes it's difficult to tell the difference between them and adverse possession. What we basically have to ask ourselves is, was the claimant's activity during the adverse possession period merely use, or was it possession? Some ambiguous situations include parking your cars on another person's land, or building a tool shed that encroaches on someone else's boundary. In the tool shed case, the answer might depend on whether there is a permanent poured concrete foundation for the tool shed, which would be possession, or whether it's merely sitting on the ground, in which case maybe it's only use. So there are some ambiguities here, some gray areas. Now sometimes, because prescriptive easements depend on being non-permissive, a court will say that permission is presumed from some or all of the following facts. And frankly, these things tend to cloud the issue of prescriptive easements and make the outcome uncertain. Is the land open and unfenced? Is the land unimproved? That is, no buildings on it. Is the land wild and unoccupied? Is the activity one that doesn't interfere with the servient owner's possession of the land? Some or all of these facts might lead a court to say that there is implied permission or presumed permission from the true owner to cross their land, and therefore that no prescriptive easement will arise. Now that we've talked about the 4 ways of creating easements, we need to ask a question about them. Can each of the 4 types be either appurtenant or in gross? Well, if we start with the express easement, the answer is yes. An express easement, whether it's created by grant or a reservation, can either be appurtenant or it can be in gross. Implied easements, on the other hand, because they are implied from prior use of one parcel to benefit another parcel, are always appurtenant easements. Likewise, easements of necessity are always appurtenant, because the whole point of an easement of necessity is to allow access to the dominant land by going over or across some servient land. So easements of necessity have to be appurtenant. Finally, a prescriptive easement, one that's similar to adverse possession, can either be appurtenant or in gross. Probably most of them are appurtenant, but an in gross easement by prescription certainly can arise, even in favor of some private individual. Most easements that are prescriptive, if they're in gross, however, are actually going to arise in favor of the public because they are a result of public use. So how could the public acquire a prescriptive easement? Well, the answer is by long continued public use of land that doesn't belong to the public, not necessarily used by the same individuals, but used by the public in general. If a public easement by prescription arises, who does it belong to? Who is the owner of the resulting easement? And the answer is normally it will be the local government, the city or the county government where the prescriptive easement is located. Now, in addition to a prescriptive easement theory, a public use might also give rise to something called an implied dedication, which can also give an easement to the public body. Why would it make any difference if the court used a prescriptive easement theory or an implied dedication theory? Well, the implied dedication might arise even though for a lesser time than adverse possession. Implied dedication requires a long period of use, but it might be shorter than, for example, 20 years that some states require for adverse possession. The other critical thing about implied dedication is it doesn't require hostility. In other words, it doesn't require any proof that the use was without the owner of the land's permission. If you were a landowner and you noticed that members of the public were going across your property, how could you prevent a prescriptive easement or an implied dedication from arising? Well, there are two standard answers to that question. One answer is that you might block off the pathway that the public is using for some period of time on a regular basis. For example, university campuses, in order not to allow a public easement to arise over the campus streets, will usually block off the campus streets with barriers one day a year. Often they will use the first day of January to do that, and they'll keep a record of it, maybe even take some photographs to show that they have done it. So that will interrupt the continuing use of the public. The other standard method, and on big city sidewalks, you'll sometimes see this, where buildings have been set back from the boundary line of the property, you'll see a little plate in the cement that says private property, permission to pass is revocable at any time. The point of that language is to indicate that the use is permission, and therefore it won't be a prescriptive easement because it won't be non-permissive. So the permission is granted by the little sign. It could be revoked in the future. In effect, it gives the public a license to use the property, but that license could be revoked. If there's a license, then no prescriptive easement will ever arise, and probably no implied dedication either. That winds up video number 35 about the creation of easements. In our next video, number 36, we'll cover the scope of easements and the ways that they can be terminated. If you have questions or comments, email ProfDale01@gmail.com. And thanks for watching.